Good morning and welcome to PV Legal's daily newsletter. Today's story is about a copy-paste arrest memo, a consignment of tramadol tablets that nobody ordered in excess, two doctors who spent months behind bars, and a Supreme Court that had seen enough. Let me take you to Amritsar, Corporate Hospital, Batala Road. A senior orthopedic surgeon, Dr. Rajinder Rajan, runs the place. Inside the hospital operates a pharmacy, Corporate Medicos, managed by Dr. Jatinder Malhotra. In April 2025, the pharmacy placed a perfectly routine order for 200 tramadol tablets with a pharmaceutical company called Ballista Pharmaceuticals. Simple enough, except that the manufacturer, apparently not great at reading numbers, shipped 2,000 tablets instead, 10 times the quantity. The doctors noticed the error. They did not open the box. They wrote back to the manufacturer asking for the return of the excess. And then, before that could happen, the NCB raided the manufacturer's premises, recovered 31,900 tramadol tablets and registered a crime. A follow-up raid at the hospital found those 2,000 tablets sitting exactly where they had been, sealed, unopened, untouched. At that point, a reasonable investigation might have asked, did the hospital benefit from this in any way? Did they sell even one tablet? Was the box opened? But the NCB had already decided. Both doctors were summoned, their statements recorded, and they were arrested and thrown into judicial custody on May 3, 2025. They applied for bail before the Punjab and Haryana High Court. Rejected. They came to the Supreme Court. Now here is where it gets interesting. The lawyers for the doctors raised a specific ground, that the grounds of arrest were never supplied to them in writing. The NCB's response? Look at the arrest memo. And so the Supreme Court looked at the arrest memo. What did it find? A template, a standard printed format with one handwritten line, and I quote, "I have explained the ground of arrest to him, her before arrest." Him, her. A blank that wasn't even filled in properly. The Supreme Court had recently decided in Mihir Rajesh Shah versus State of Maharashtra that grounds of arrest must be communicated in writing, and if given orally, a written memo must be supplied at least 2 hours before production before the magistrate. The NCB did neither. The court noted with quiet devastation that the NCB had not even bothered to rebut this ground in their counter-affidavit before the Supreme Court. Result? Both doctors released on bail forthwith. The lesson for every enforcement agency, NCB, DRI, Customs, everyone, is this. The Constitution of India is not a suggestion. Article 22 is not optional, and a template arrest memo with a him/her checkbox is not constitutional compliance. This is your host signing off from PV Legal's daily newsletter. Stay informed, stay compliant, and remember, the Constitution protects everyone, even from the people who are supposed to protect us.